Hi, this is Kirk Davis with Camps. I'm here today with Joshua Brittingham from Carney Badley and Spellman. You can see that on the screen. He is a wage and employment attorney. Carney Badley and Spellman are new members of Camps. We were discussing the fact that the kind of law that you practice, Joshua, is very relevant to many of our members. There's
Right.
implications, there's things they need to know. So I thought I would just
Absolutely.
start off with this idea of what is wage and hour law? How would you describe that to a business owner?
I would describe it as scary. And just to back up, in terms of who I am, I help manufacturing companies with sticky employee situations so they can stay out of legal trouble and just get back to making the cool and useful products that they make. And I do it because I've seen firsthand how hard it is to run a business. Both of my parents are small business owners, and I've watched them deal with those challenges. And so it's near and dear to my heart. But wage and hour law, yeah, it's scary. That's one way to describe it. It's a bunch of rules. It's focused really on what the term says. It's how much people are paid, how much employees are paid, and when they're working and when they get breaks and time off. And that really is the simplicity of what wage and hour law covers. But there are a lot of landmines. So there's a lot of things people know and are completely aware of. Obviously, minimum wage, everybody knows about a minimum wage. That's part of it. That's pretty basic. I think that's pretty easy to comply with. Overtime rules, when you have to pay time and a half, that sort of thing is also
Yeah, the
part of it.
rules.
Paid sick leave. And then a big area that is an increasing challenge for compliance is with meal breaks and rest breaks. And so that's one of the things that I think we probably want to touch on. In addition, part of the reason it's scary is local laws. Now, there's the federal government that's involved. States have rules. Washington has its rules, and the cities have got involved. So Seattle, Tacoma, and increasingly other cities have decided they want to weigh in on employment laws and these wage and hour laws. So it just creates a huge headache for compliance. There's so many places to look. You're like a dog looking every which way to make sure you have even figured out what the rules are before you even start to comply with them. So that's it in a nutshell.
Joshua, let me just explain from my career experience. I think employers do the best they can. Sometimes they're going off the cuff, sometimes, but if they're not paying strict attention to these types of things, their employees are. And their employees
Right.
kind of know the rules, not all of them, but they know a lot of them. And they know if they're not getting their breaks, they know if their overtime wasn't paid just right. They're paying attention to their pay stubs. So what I've seen in the past is where employees they take it for a while, but after some time of being treated what they consider to be unfairly or not in compliance, employees go after them, and it hurts everybody.
You're 100% correct. Yeah, that's exactly what happens. So I think one of the challenges is that compliance is difficult. The rules are not complicated. We all probably know you need to give a 30-minute lunch break, but we also have busy businesses to run, and sometimes people get 29 minutes, right? And so that's technically non-compliant. So what does that mean? Usually it means nothing. People go back to work, everybody's fine. But what can happen is what you described is they note that every day I have 5 minutes less. I'm pushed to go back 5 minutes early from lunch, or I miss 3 minutes of my break. And then they become bitter and they decide, you know what, I'm going to bring a claim. Or maybe they talk to a friend of a friend who's an attorney, or they read something and they realize, wait a minute, this isn't technically compliant. And suddenly you're dealing with a claim. And so that's exactly how it goes. It also, one thing about wage and hour law and even just employee relations in general, it's a little bit like like a relationship, I guess, like a marriage almost. Like if everybody's happy, there's not usually issues. You're not going to sue your spouse until you're going for a divorce. So
Right.
if people are happy, they may say, I don't really care. In fact, sometimes people are happy to skip lunch because they want to go home early or something like that. But even that isn't compliant. So sometimes you're dealing with people who the management is fine with everyone skipping lunch, but employees are fine with it. But the state isn't. The judge is not going to be fine with it. There's
And
different layers where you can get in trouble.
one of the things that I've seen is more the human side of it, where
Yes.
everything's happy. And like you said, employees make sacrifices. Sometimes employers make sacrifices. But after a while, it's just, well, it was a friendly, really give and take. everybody wins relationship turns sour by surprise sometimes. And so it's like you can't really see these things coming. And so you're much
Right.
better off to have these type of things in your employee handbook. So I'm sure that prevention is 90% of the solution here.
100%. Yeah, that's one thing I've learned from litigating all kinds of employment cases, many wage and hour cases, is you really never know who's going to sue you. It may be the person you least expect. And yeah, an ounce of prevention is certainly worth a pound of cure. And the good thing is there's lots of things that you can do. The list begins with taking inventory, doing an audit. That's the first thing that you want to do. And our team has a standard process. You want to look at each of your job positions, make sure they're classified correctly, because that's something that's important in terms of exemptions, whether they're just paid a salary as an exempt employee or whether they should be paid hourly. That's critical because if you get that wrong, if you've paid them as exempt, you probably aren't tracking their hours and you have no way to prove if they were paid for the number of hours that they're claiming. And then you look at payroll practices and, like you said, policies, and usually those are within a handbook. So, at the very least, you need to have a compliant handbook policy or other policies about these issues. Because if you don't, a plaintiff's attorney is going to throw that in your face as exhibit A of your failures as a company. And so, yeah, that's absolutely correct. Another big component of it, though, is training because it's one thing to have the documents and it's important, it's a necessity, but you have to go beyond that. And so it's really manager training. And I don't necessarily mean C-level, C-suite executive management, although that's important to some
Yeah.
extent. But I mean your inline supervisory type managers, they need to be very aware of what the rules are because there are obligations. For example, it's not good enough to say we told them they had a rest break and they didn't take it, that's on them. That's actually not okay. There's an obligation to go beyond that and make sure they're getting there 10 minutes. And if it's interrupted, then they need to get the remainder of that time. And the same is true with meal breaks. So management training is crucial. And I often do that for clients. They will have us come out and just explain, here's the rules, but here's the practical reality. You can't just ignore it, or you can't just say, hey, yeah, this employee, they want to skip their breaks and go home early. That's fine. I'll let them go home 30 minutes early. It seems nice, it seems kind, but it's not a good idea. You're out of compliance.
Joshua, I wanted to say to our audience here who's listening that manufacturers deal with compliance all the time on all kinds of issues, and they understand the difference between it's in the manual versus do we really do it, right? So there's
Right.
this thing, and what I'm so excited about meeting you and talking to you about your team and what you do is this is a very big part of risk management for manufacturers. And that is, as they're thinking through their risk management strategies, I just think it'd be great to reach out to you, to your team, and to say, are we compliant? Are we actually doing these things? Even if we have it in our handbook, even if we have the policy, are we enforcing it? And maybe not enforcing it negatively, but enforcing it positively by training your inline supervisors. Is there a training
Right.
practice? And I'm wondering, could you explain what happens when a company gets a claim for employment law? What happens if they get a claim or a notice?
Yeah, so it can happen a few different ways. And oftentimes it will come through what we call L&I, the Department of Labor, or the Federal Department of Labor, that version of it. So an agency complaint, and you have an opportunity to respond, and then the agency will investigate and determine if they're going to take action. It can also just come in the form of a lawsuit, which is just a civil suit for damages based on noncompliance. But the worst case would be a class action.
Mm.
And that's what I'm seeing a trend of. For those who keep kind of their finger on the pulse of this, they know that California is notorious for wage and hour class actions. And what I'm seeing and our team is seeing is a trend of California firms finding local counsel up in Washington, and they're bringing their, I call it an epidemic, but I'm biased, but they're bringing their wage and hour class actions and their experience bringing those lawsuits up to Washington because it's just it's a ripe area to find noncompliance. And so what happens, it's you just get a document served, usually on somebody in the corporate office. There is a process to respond, and then you begin to evaluate the claims and you do exactly what You go back to what we were talking about. The first thing you look at is you say, do we have a compliant policy? And then you begin to look at what were the practices, what actually happened. And particularly for the class actions, but any kind of claim really, you will go out with our team and we'll interview folks and find out what's actually happening on the ground. And sometimes that's revealing for management. Sometimes they will be surprised to hear what was actually going on and what their supervisors may have been allowing or turning the other way and just ignoring. And so there's an investigation period, and then there's just ultimately a lot of cost and disruption because
That was
if
my
you
thought.
and yeah, I mean, there's depositions, so that's testimony. It's like this sort of. Nowadays, we do a lot of Zoom
Yeah.
depositions, so it's an interview, but it's under oath and it's painful and time consuming, and there's a lot of prep involved. So now your employees and your management team has to be prepared for those. All of that takes away from your day to day of doing good work and building things, right? Producing things. And then legal fees are expensive, right? And it really is disruptive and costly to your business. And so, depending on how strong the claims are, oftentimes you can settle these cases sometimes early. And that's very frequently a good way to deal with it. But the best case scenario is that you've got all your ducks in a row and you can say, wait a minute, our policies are compliant, our managers train folks. For example, and obviously I can't get into specifics, but I've had just a particular client in mind who shall remain nameless, who we did this process with, and we went out and it was a break issue, a rest break issue. And lo and behold, people said, "Oh, we had lots of downtime. We were sitting around all the time. We took way more than the 10 minutes of breaks. And we actually got statements signed under oath that said we got multiple minutes of breaks, well beyond what was required." And Washington does allow, unlike some states, that you can have in certain contexts an intermittent break. It's harder in manufacturing due to the nature of it, but in some contexts you can. And so now we've got a stack of paper we can show a judge that says, hey, wait a second, we've got all this evidence that there was compliance here. But it can also be the opposite. I've had the very opposite where you go in and you interview and they say, yeah, I didn't really take my breaks and I just worked through the day. And that could be a very happy employee, fine with the company, but that's not a very
That's a
helpful bit of evidence.
precedence. Yeah.
No, it's not going to be good for your chances of either resolving the case or winning the case.
So one of the things you mentioned, and so I kind of love the thought process that you've talked about of having being compliant in your policies, being compliant in your training. But would you talk just for a moment about tracking? What kind of things do you recommend employers track? And so that if there were a claim, if there were an audit for some reason, they would have all their paperwork.
There's a number of things. Some of them are basic that everyone probably in the audience would be doing. You want to be tracking acknowledgments of the handbook and the policies that are being provided to make sure people have seen them. And there are systems for doing that. There's more and less sophisticated versions of that. A big one, though, of course, is your timekeeping and payroll records. You need to have a good time clock system, and there's all kinds of sophisticated systems out there. You can get them on phone apps. You can in manufacturing. Frequently, it's at one of the entrances to the plant. But it's not enough to just have the system because unfortunately, sometimes they can be set up where they round, and rounding can create problems and can create compliance
That's good
risks.
to
So,
hear because that's
yes.
something I would not have thought of at all.
Yes, and so you have to really honestly the best thing to do would be to get the system, but also work with legal counsel to make sure that the way you've set it up is appropriate because it's one thing to have data from your timekeeping system, but a lot of times we've seen examples where they'll clock in at a certain point and then they'll say that there'll be issues about when they actually started work and what that looks like, and that can create compliance issues. And so you have to be mindful of it's not enough to just throw in a system that may perhaps somebody sold you on a great system, and it may be a great system, but you also have to be thoughtful about how it's being implemented and things like how long it takes to walk from where you clock in to when you actually begin your shift. That matters because that time can be compensable and is it being charged and are you rounding? And so all of those things they need to be on your radar. You need to think them through because
Wow.
if you're in a lawsuit and you didn't do it right, and sadly I've seen this in the manufacturing context, what's going to happen is you're going to be paying. I just settled a case and The client
Well,
had to pay, and it's less than it would have been by a large amount, but it's not a fun amount to do.
can I ask you from what you've seen over the years, and you
Yeah,
have great experience in this, but a lot of times when companies are small or newer, they
yes,
might tend to be a little more Wild West without all the policies or tracking, and
sure.
they're maybe a little more loose on the rounding or where the time clock's located. So they might be a little looser on these things. But then as they grow, even if they took some time to get compliant with all of the right best practices that you're outlining here, do you see that, I don't know, policies change over time or the way the law approaches this? In other words, is it good to check back in on this again?
Oh, absolutely. That's another part of the reason I say this is a scary area of the law because the rules change, especially in Washington and states like Washington, they change on an almost annual basis. And the minimum wage changes, that's pretty easy to
Yeah.
keep track of. But exemptions change, the threshold for whether somebody should be considered exempt. That yes, it's constantly changing, and that's one thing that we keep our finger on the pulse of is just what are the new rules coming out? What's the legislature doing? And yes, I highly recommend an annual policy and handbook
Oh,
update.
that's a
Um,
great best practice, by the way. Yeah.
it is, and our team does that because they do change, and what may have been fine a year or two ago could be completely out of compliance now. And so you have to stay on top of this.
Am I incorrect in thinking that Washington State, generally speaking, is very favorable towards employees?
No, you were completely correct about that. Yes.
So I think as an employer, you have to think through the fact that the state, maybe legally or policy wise, really favors the employees. And therefore, it's even more important, maybe in Washington State, to really dot your I's, cross your T's, do follow up meetings with your team.
That's absolutely true. I have colleagues who do wage and hour law across the country, and in some countries, it's like shocking to me. It's not countries; they feel like other countries, but in some other states, there's almost no protection. Some states don't even require breaks. Whereas out here, it's both the rules and the laws are very favorable to the employee, but it's even worse than that because it's also the jury pool, and that matters because juries are very fickle. And so not only are the rules stacked against you, if you did end up in front of a jury on any kind of an employment issue for the most part, and that it can vary by county, I'll grant you that, but particularly on the western side of the state, a jury's likely, if they're not sure, they're likely going to punish the employer. And that's just the reality of what you're dealing with. Whether that's correct or not, that's another risk that you have to consider. So,
I think
yes,
it's so good to talk about that. Yeah.
yeah, you really need to go above and beyond to dot your I's and cross your T's to do whatever you can for compliance because it really is stacked against the employer in Washington.
I'm going to recommend just a couple of things after hearing you.
Yeah,
And that is get to know Joshua and his team. I just think that this is complex enough. I think it changes enough that it would be a wise best practice just annually to just have a review with Joshua and his team. I think understanding that in this environment, and you mentioned even with the juries, why not play to win? Just be compliant, follow the best practices, but have this be an area that you don't worry about, you don't lose sleep about.
what 100%. And that we have when our clients do that, they feel like they understand what the risks are and what they need to do. It gives them kind of an action plan, and as opposed to just wondering and not knowing. So it's not an area you want to stick your hand in the sand in. And like you said, manufacturing is often quite regulated in many respects. And I guess I would just say add wage and hour to the list of the areas that you want to keep on your radar and really manage the risk there because it's always been an issue and a risk in Washington. And what I'm seeing is there's a kind of a wave of, I would probably say on a daily basis, I watch the filings of court cases, and probably every day there's at least one wage and hour class action filed.
Crazy. Oh,
And
wow. Class
it's
action.
crazy.
Oh, yeah. I
Yeah,
mean,
class action,
oh, that's
certainly
big.
wages, but I'm talking right now, there's just a big push for these class actions. And the problem, of course, is if one person brought a claim, the damages are, it's the time that you miss for the breaks, and it goes back generally 3 years. So it's not a huge sum usually, but when you multiply that by 50, 100, or 1,000 employees, it's now a very astronomical sum of potential downside if there's a bad judgment. It's very scary. And it's a lot. And you just want to know that you've done your best. The cost of prevention is way less than dealing with that, even if you can settle it, because they're just awful.
One of the things I have seen across the board with manufacturers, where a place where there's just absolutely no compromise and they're excellent at it, is employee safety. They
Yes,
prioritize that.
yes.
They follow every rule. I've never seen better taking care of employees in terms of safety. And just like you said with other areas of compliance, I would just treat this wage and hour law as seriously as you treat your safety for your employees. It's good for them. It's
Yeah,
good for
that's a great way to think about it. Absolutely, yeah. And honestly, the rest break requirements that are such a focus right now, there is a safety element to that. Part of it is for that. If you think of it as a safety issue, or at least to have the same kind of importance and elevate it, then absolutely, I think that's appropriate.
Yeah, and what's so helpful today meeting you, Joshua, and hopefully everybody's getting a feeling of how, first of all, how nice it is to talk to you, but how knowledgeable you are. And so I highly recommend they're members of camps. We're really excited to have you guys on board because you guys really play well to the manufacturing space. And we could hear in your examples and your stories that the manufacturing is an area that you know very well, and that's helpful to us.
Yeah, it absolutely is. It's one of our big focuses, and it's an area where extra strict compliance is just required. There are certain industries where you can be a little bit more lax with some of these rules, although not too lax, obviously. But manufacturing, and I'm always impressed with my manufacturing clients. And when I go out to interview the employees, because we ask questions like, well, okay, when do you arrive at work? And in some industry, and for what, like my own, I wouldn't know when I get to work on a daily basis.
They
But in
know. Yeah.
manufacturing, they always know. I arrive at 5:23 a.m. Okay, and then what do you do? I sit in my car till 5:30. Then what do you do? Manufacturing is so precise, and that's great, but if you are out of compliance, it's very easy to show that
It,
because everybody's precisely out of compliance, and it makes manufacturers a great target, unfortunately, because
yeah.
they know everybody says they got back from lunch at 12:37 and that's 7 minutes too late. It's a very precise industry, which means you have to be very precise and focused about these rules.
Yeah, and I'm thinking of the people I know already in manufacturing who
Yes.
they're really strong on this and they believe in it. And I even think that the things that you've shared today are going to be really helpful to them. The people who are good at it are going to say, "Oh yeah, there's some things we should just double check, look at, make certain we're doing everything to protect." Essentially, it protects the employees, it protects the company.
Yes.
It's an area that why step in that trap if you don't have to?
Absolutely. And I would just add to that, I completely agree. And I would add that just don't assume, because I've seen clients where management at the higher levels assume that HR or even local legal counsel in Washington had covered it, right? And I'm not throwing anybody under the bus, but in some cases it wasn't covered, right? So don't assume, ask questions. Have we got this covered? Are we looking at this? And if you're not sure, then yeah, my team can help. Get legal counsel because you don't want to find out after the fact when you've been sued.
I'm certain, Joshua, and I'm just imagining the conversations you've had. I'm certain that every client is surprised.
That is exactly correct. That find that to be very true. People are like, wait a minute, what's going on? It's not a feeling of, oh, we thought this was coming. It's a feeling of shock.
Yes.
And how can this be? And then the next feeling is a feeling of what's our damages and can we even survive this, depending on the
Yeah,
size of the claim.
absolutely.
It's very difficult. So, but
No, I
much
love
better to get ahead of it.
I loved what you said about don't assume because, and that's why I was saying that I'm certain that people come to you and they're pretty shocked that this happened, that they weren't in compliance, that
You
they,
were right. Yeah.
and so that's why I loved your axiom here of don't assume because really this is just an area that it's a good idea, it's good for the company, it's good for the employee, and
Yeah.
it's really good for a future that's free of claims and audits and trouble.
Absolutely. Yeah.
I'm delighted to have had you here today. I'm going to put all of your contact information. We'll be sending this out by email and it'll be on YouTube. And so we'll have all of your contact information there.
Perfect.
Make it easy
Yeah.
for our members to find you.
Great. I'm always happy to chat with members. They don't need to be formally engaged as a client. If people have questions or just want to bounce
Thank
off some
you.
ideas, we're always happy to do that. And so, yes, please reach out. We've got a great team and we're here to help. And we certainly know manufacturing.
I appreciate the invitation that they can reach out without having to be engaged as a client, and they
Yeah,
can talk through issues. And it's always nice to have that kind of a relationship where we know we can come and talk to you.
absolutely. That's what we're here for. And it's a great industry and we've found just to be great people to engage with. So we're happy to do
Thank you
it.
so much.
Thanks so much. Appreciate it.